Good morning, everyone. Welcome to the webinar. My name is Ju Hong, and I'm with the Department of Social Services Immigration Unit.
My name is Eli Tuiscu. I'm with Research Services Branch.
Today's webinar is being presented by Immigrant Defenders Law Center and Vera Institute of Justice. And today's webinar is being recorded. We will be able to share a link with you and the presentation slides after the webinar is complete. Please feel free to revisit the content yourself and share with your colleagues. Before we begin, we have several housekeeping rules. First, please press the text box icon in the lower left corner to open up chat box. Participants can write in questions at any time during the presentation. Facilitator will collect questions in the chat box and pose questions to the presenters during the Q&A session at the end. And please note that participants' audio will be muted throughout the presentation. At this time, I'm going to hand the floor over to Lindsay from Immigrant Defenders Law Center. Lindsay?
Good morning, everyone. Thank you so much for hosting this CDSS. And I'm going to go ahead and jump right in because we have a lot of material to cover. My name is Lindsay Toslowski. I'm the Executive Director at Immigrant Defenders Law Center. And later in the webinar, I'll be joined by my colleagues, Meeth Soni, IMDEF's co-legal director, and Shayna Kessler, who's a senior program associate with the Vera Institute of Justice. Just to give you an idea of what we'll be talking about today, the first half or so of the presentation is going to be an overview of the federal agencies that interact with separated children. I'm going to talk about the flow of unaccompanied children through the immigration system. I'm going to talk some about how they're placed, what care they receive when they are in Office of Refugee Resettlement custody. And I'm also going to talk about what it looks like and how the process works when they reunify with a sponsor in the United States. My colleague Meeth will take over and talk about an overview of the legal services needs and considerations for separated parents here in California. And then Shayna will jump in and talk about connecting parents and children, about Vera's very exciting new resource, the Immigrant Connection or ICON system. So jumping right in, I'm going to start by talking about the flow of unaccompanied children through the immigration systems. And I just have to warn everyone in advance that we are now entering acronym landia, as we like to call it. In immigration law, as many of you already know, there are a lot of acronyms. So I'm just going to go through those for those of you who are not familiar, so that you know which agencies we're talking about. So we have the Department of Homeland Security, which we refer to as DHS, Customs and Border Protection, which we refer to as CBP, U.S. Citizenship and Immigration Services, which is USCIS. One you're going to hear a lot about today is the Office of Refugee Resettlement, ORR, and I'll refer to them as ORR throughout the presentation. They are part of the U.S. Department of Health and Human Services, which we use the acronym HHS to describe. And then, of course, DOJ, which you're all familiar with, the Department of Justice, and EOIR, which is the Executive Officer of Immigration Review, or the immigration courts, as they're more commonly known. So I'm going to start by giving you the federal definition of unaccompanied alien children. So unaccompanied alien children are minors under the age of 18 who lack lawful immigration status in the United States, who are without a parent or legal guardian in the U.S., or who have no parent or legal guardian in the U.S. that's available to provide care and physical custody for them. So the determination of whether someone is described by this definition is made at the time of apprehension. I'm going to talk a little bit more about how this works within the context of separated children, but traditionally these would have been, prior to zero tolerance is what I mean when I say traditionally, these would have been kids who were caught crossing the border, who at the time of their apprehension had no parent or legal guardian with them in the U.S. that they could be handed over to. Now, within the context of zero tolerance, it's also children who have no parent available to care for them because they've been separated from that parent. So the acronyms that are used to describe unaccompanied children are UAC, which is the most commonly used federal term. We're going to use throughout this presentation unaccompanied children, just UC. But also here in California, we also use unaccompanied undocumented minors. But for the purposes of today, I'm going to use UC as the acronym to describe these children. So prior to the implementation of the zero tolerance policies, which started in April of this year, separations did occur, but they occurred very rarely. And most of the time when these separations occurred, it was because of there being a child welfare issue with the parents. Usually it was either there was a child welfare issue or that the parents couldn't prove their relationship to the child. But again, we saw this very rarely, and starting in approximately April of this year, we started to see it happen in every single case. And the numbers are a bit fuzzy coming from the government right now. They haven't given specific numbers in almost 2 weeks. But we believe that as many as 3,000 children may have been separated from parents and caretakers at the border over the 6-week period beginning in April and ending with the executive order. At the time of separation, the children are designated as UCs. They're placed into ORR custody, and the parents either enter ICE custody or they go into the custody of the U.S. Marshals, where they will face criminal prosecution for illegal entry. So in thinking about this presentation over the weekend, I started to, try to answer this question about whether there was a system created by the federal government to track separated parents and children. And the simple answer is that no, there wasn't. And while I was thinking about this, I was actually with my own children at Chuck E. Cheese, where when you enter that restaurant, they give you a stamp on your hand that can only be seen with a black light that matches a stamp on your child's hand that tracks you in case one of you tries to leave without the other. And it occurred to me that that system is more complex than the system that appears to have been created by the federal government to track children and their parents. And the reason that a system was so necessary is because once children enter the ORR system and the parents enter another system, either the U.S. Marshals custody or ICE custody, those systems actually are not used to interacting. There's no shared database that was making sure that as the parents went into ICE custody and into removal proceedings, that they were linked back with that child in ORR custody. So as hard as it is to believe, there does not seem that there was any sort of federal government mandate from the beginning that actually tracked these children. And we're seeing that play out in a courtroom in San Diego this morning where, and I'll talk more about this later, where the government is asking for more time to be able to reunite children with their parents because there is no system that has efficiently tracked them. So I'm going to talk now about what happens once a minor is designated as a UC and what protections apply. So something you may have heard about because it's been in the news a lot lately is that the Flores Settlement Agreement. And this is one of the preeminent protections for children once they are in custody. This actually grew out of allegations of UC mistreatment that led to a series of lawsuits. And eventually in 1997, the government agreed to the Flores Settlement. Some of the key obligations of the government under the Flores Agreement are that children must be released without unnecessary delay to parents or other adult relatives or to a licensed program that's willing to accept custody of them. And in cases where this is not possible, the minor must be placed in the least restrictive setting that's appropriate to that minor. And it also mandates the standards of care for children in immigration detention. So some of you may remember in 2014, under the Obama administration, they began to hold families in family detention centers for prolonged periods of time. Advocates challenged this and actually said that the unaccompanied minor protections in the Flores settlement are for all children and that they apply to everyone, whether or not they're accompanied and held in family detention or they are truly unaccompanied, meaning that they don't have any parent here in the United States. And so they saw prolonged family detention as a violation of the Flores settlement. Well, the Ninth Circuit in 2015 agreed with the advocates, and the Flores settlement was clarified that it covers not just unaccompanied children, but also accompanied children as well, so children who are detained with their parents. And the court set as a general standard that the government cannot hold accompanied children in ICE custody with their parents for more than 20 days. The reason that this has been in the news lately is because on June 20th, Trump ordered Attorney General Sessions to seek amendments to the Flores settlement. And the two specific requests that they had in that amendment that they filed, or that request that they filed, was that the requirement that children be released without unnecessary delay be removed for children who are detained with their parents. And they also asked that the requirement that children who cannot be released from custody without unnecessary delay, that those children be placed in state licensed facility, they asked that that also be removed. One of the reasons is because in some states, there's ongoing litigation about whether or not ICE detention facilities can be state licensed for the care of children. This has particularly been an issue in Texas. And so because that litigation is ongoing, the Trump administration is seeking to be able to remove that requirement. So this is something that is going to be decided right here in Los Angeles in federal district court. But if, what happened in the decisions that were made in 2014 and 2015 are any indication, it's unlikely that the government that the courts are going to agree with the Trump administration's assertion that children should be able to be held indefinitely with their parents in family detention centers. So some of the additional legal protections that exist for children once they're designated as UCs, and again, just to reiterate, these additional legal protections in the Flores settlement are for children who are traditionally unaccompanied children, meaning they crossed on their own, or who became unaccompanied when they were separated from their parents. But another important additional legal protection is the Homeland Security Act of 2002. And what this did is it divided the responsibilities for the processing of treatment of UCs. The DHS has been designated to handle the apprehension, transfer, and repatriation responsibilities related to UCs. And then ORR, which is part of the Department of Health and Human Services, is tasked with coordination and implementation of care and placement of UCs in appropriate settings. They also are in charge of the reunifying UCs with their sponsors in the US or with their parents in a home country. They also maintain and publish a list of legal services available to UCs, and they collect statistical information on UCs who are in their care. So this was really important because prior to this, DHS was actually responsible for the treatment and the care of these children. But now that is something that has been designated as the Office of Refugee Resettlement and HHS's responsibility. So another important, and maybe the most important legal protection for UCs is the Trafficking Victims Protection and Reauthorization Act of 2008. And this is another acronym for you that you'll hear a lot, the TVPRA. The TVPRA reaffirms that the transfer of responsibility for children is in the custody of HHS and ORR, and it also creates guidelines for the release of children to family members or other adults. And the idea behind the TVPRA is that those reunification guidelines will minimize the risk of trafficking for these minors. And it sets out a process by which it's child welfare focused, meaning that the welfare of the child is the guiding decision making in terms of reunification. A really important protection that the TVPRA creates is that it makes it so that unaccompanied minors are not subject to expedited removal proceedings. And expedited removal proceedings will be covered later in the presentation in greater detail. But essentially what the TVPRA does is it gives minors the right to see a judge before a decision is made on their removal. And so this is a procedural safeguard that gives them a full removal under the INA Section 240. And once a minor is in 240 removal proceedings, there is a judge who will actually be able to look at their case individually instead of ICE being able to be the final decision maker. Additionally, the TVPRA provides asylum protections for minors. Minors are held to the same legal standards as any person, but it does allow them to have their case heard first by USCIS, which gives minors the chance to present their asylum case in a non-adversarial setting instead of going directly to immigration court for their asylum case. And additionally, the TVPRA amended the requirements for special immigrant juvenile status eligibility, making minors eligible for that visa if they can show that they were abused, abandoned, or neglected by one or both parents. So let's talk a little bit about how these protections for UCs work in practice. At the border, prior to zero tolerance, what would happen is CBP would apprehend unaccompanied children at or near the border. The CBP officer would then interview them to determine whether or not they are younger than 18, whether they're unaccompanied, and whether they're from a non-contiguous country. And I'm just going to stop and give a little bit of a side bar here about that non-contiguous country requirement. The TVPRA only protects minors who are not from Mexico or Canada. So for a minor, and on the southern border, we mostly see this with minors from Mexico, they are not automatically entitled to all of the protections of the TVPRA. And that's why we actually see a very small number of Mexican minors in the ORR system. They can be voluntarily returned to Mexico if the CBP officer who interviews them determines that they don't have a fear of return and there's no risk of trafficking. But for minors who are from non-contiguous countries, which of course includes children from Central America and other parts of the world, once they've determined that they're younger than 18 and unaccompanied, they have to refer those minors to ORR custody. And that decision and that transfer should happen within 72 hours of identification. However, as we see strains on the system and more minors being added into the ORR system, we do sometimes see that 72 hours stretched for long periods. And in fact, in 2014, we saw it stretch sometimes for weeks on end. So it's an important, when you're screening unaccompanied minors and children who've been separated, it's important to ask them how long they were in CBP custody, because you may be able to form a complaint for them if they were held for long periods of time prior to be transferring to ORR pursuant to these regulations. And the reason this is important is because while in CBP custody, conditions can be unsafe and even unconstitutionally cruel. You can see the photo that I've used on a slide here, which is a photo from 2015. And this is something that our friends at the National Immigration Law Center have been working on for a long period of time, which is the treatment of families and children and adults when they're in hieleras on the border. So these are cooling centers that CBP runs, but as you can see from the photo, they are basically cells. They're extremely cold. You can see people are laying on the floor. There's even a baby crawling on the floor near a bathroom. The conditions and the complaints of abuse by unaccompanied minors are often from when they are in CBP custody. And that's why we want to hold the government accountable when minors are in CBP custody for more than those 72 hours. Because CBP is not set up to be caring for minors in the way that ORR and licensed facilities are. And so this is a really important issue, and I encourage you to go to the National Immigration Law Center's website to learn more about that specific concerns about hieleras in Arizona and Texas. So, you know, the big question that everybody has right now is what has changed under zero tolerance? Well, previously, families arriving as a unit would generally be kept together. And that meant that they would either be paroled in for the purposes of seeking asylum if they expressed a credible fear, or in some cases they would be held in family detention for short periods of time, less than 20 days. However, under zero tolerance, every single adult entering is subject to criminal prosecution for illegal entry. So although the executive order has stopped this for now, what we were seeing for approximately that 6-week period is that every adult who entered with a minor while they were in CBP custody would be separated from that minor, and the parent would be taken into U.S. Marshals custody, and the children would be designated as unaccompanied and referred to ORR custody. So my colleague Neef is going to talk more about what happens with adults, but I'm going to start by telling you what happens with the kids. So once the children go into ORR custody, ORR actually picks them up from Customs and Border Protection and then brings them to one of many shelters throughout the country where children are placed. ORR contracts with a network of shelters around the country. And minors have to be, and just a reminder for people not to press the take over as presenter button at any time during the presentation. So once minors go into ORR custody, they have to be placed in the least restrictive setting that's appropriate for their age and special needs. The vast majority, more than 80% in 2017, went into shelter care facilities. Shelter care facilities are essentially large or small group homes licensed by the state where minors are held while they are seeking reunification and while their removal proceedings are ongoing. Another form of care that children can be placed in, and this one has caused a lot of consternation in the media in the last few weeks because it's very poorly understood. It's called transitional foster care. And transitional foster care is generally for younger minors who may not do well in a group shelter care system. And it's short-term foster care where they're placed with a family, they live in a home, and this is not meant to be permanent foster care or foster to adopt situation. These are foster care homes that are meant to be short-term, just like shelter care. While the minors are in that care, they do live with the family, but they are under the supervision of agencies that run those foster homes that are contractors with ORR. There are also two secure facilities called Staff Secure and Secure, and these are for minors generally who have behavioral or issues where the sites are concerned that they may try to flee a facility. And these are secure facilities. And in fact, in California, these are facilities that are juvenile detention-like facilities. And then the other place where we do see minors placed are in camps or other emergency facilities. Some of you may remember that Port Hueneme in 2014 was used as a large-scale camp or facility for housing minors. And generally what we saw then was that minors who were likely to be reunified very quickly because they had parents in the United States who were not in custody were held in those facilities for short periods of time. Given the current crisis and humanitarian crisis that the government is facing, they are already talking about opening some of these camps in other locations around the country to house minors. And that's because of the real stress that's been put on the system by having separated minors entering a system that was already near at capacity prior to the separation crisis. And, in real numbers, what we saw at the height of zero tolerance was as many as 300 children entering the ORR system each week. And that was on top of the numbers that were already coming into the system that was not designed for that many. So it's very likely that given that many of the sites around the country are at capacity, that other camps like this may open. And we've already seen that happening, of course, in Texas with the tent cities that have been created. So in California, the facilities that house unaccompanied children are licensed through community care licensing, which means that the state of California and CDSS actually license those facilities for the care of minors. So ORR, when they have children in their custody, they are mandated to provide those children with education, mental and medical health services, case management, family reunification services that help the children to be reunited with family members or other sponsors that can care for them in the United States. They conduct and contract with agencies to conduct home studies prior to releasing children if necessary for child welfare purposes. And then in a limited number of cases, they actually provide follow-up services for at-risk children after they've been released. In 2017, the average length of stay in an ORR shelter was 41 days. Because there has not been enough time since zero tolerance for us to see, we'll have to wait to find out whether or not that average length of stay is extended for children who've been separated from their parents. But certainly we're seeing lots of stories in the media about parents who are now out of custody and are desperate to be reunited with the child that they were torn away from. So certainly the reunification process, and also because of the litigation happening with the Ms. L case, ORR is going to have to truncate the process that they normally use. So while UCs are detained in ORR custody, they are receiving legal services through the VERA network, which is a nationwide network of legal service providers. So ORR contracts with the VERA Institute of Justice to manage a national network of 39 legal service providers that provide assistance to children throughout the country. So in the Los Angeles area, they contract with Immigrant Defenders Law Center, and also other providers here in California include Kids in Need of Defense, Casa Cornelia Law Center, and Legal Services for Children, who work with detained youth. The children, while they are in custody, they receive Know Your Rights orientations. So every single minor receives a presentation either in a group setting or individually so that they understand what's happening to them, what they're doing in these detention shelters, and what they can expect if they have to go to court while they're in custody. We also meet with every single child to identify their legal needs and provide an individualized screening so that we can explain to them what types of immigration law they may qualify for. We also recruit, train, and mentor pro bono attorneys, match children with pro bono representation around the country, and here at Immigrant Defenders, we provide direct representation to a large number of these minors, both when they're in custody and after they're released. And legal service providers also communicate directly with the caseworkers at the shelter, intervene with the reunification process when necessary. We work with ORR staff, child welfare practitioners, the immigration courts, all with trying to ensure that the child's legal interests are protected throughout this process. So what you see on your screen right now is actually an image of a flyer that the U.S. government was giving to detained parents at the Port Isabel facility in Texas. And you might notice that the flyer itself is in English. So it had limited practicality for many of the parents. But it did provide a number for the Office of Refugee Resettlement where parents could call. There's been a lot of reports of parents being unable to access telephones, access information. We'll talk a little bit more about how that's happening locally here. But to say the least, this has not been a perfect system. And unfortunately, due to privacy concerns for children, it's not possible to find unaccompanied children via online locators that you might use to find parents, like the ICE inmate locator. So one of the things that we'll talk about later in the presentation is how nonprofits have really stepped in to be the link for parents who are looking for their children. And my colleague Shana from VERA will talk more about how you can utilize that later in the presentation. So who can sponsor a UC out of ORR custody? In this current crisis, we've been getting a lot of people asking whether or not they can become foster parents, whether they can sponsor a child. The person who is absolutely the most favored category is a parent. They're considered a category 1. So if there is a parent in the United States and they can prove that relationship that they have with the child, they are the preferred category for ORR to release a child to. Legal guardian is also near the top. Other adult relatives, and we see this very commonly with adult cousins, adult aunts and uncles, also an individual or entity designated by a parent or a licensed program. So how do families actually do this? And this is a big question, particularly for us here in California, as we see more parents leaving custody from around the country and coming here and seeking our services. So once a child's been located, ORR should give the contact information for the child's case manager, who's tasked with the reunification to the parent. The case manager will work with the family to complete the very long and complicated family reunification application. It's actually 32 pages long, and have them sign a sponsor care agreement. It's not meant that this process should require an attorney. In fact, the case managers say that you don't need to hire an attorney to do it, but certainly in these separation cases, many legal service providers are going to be asked to help with this process. And so you can go directly to ORR's website and download the application so that you can familiarize yourself with this process. The fingerprints are required for the sponsor, including parents and all adult members of the household. And I'll talk about why that's a real challenge moving forward. And the application process is free. I did want to point this out because we have had reports here in the Los Angeles area of scam artists trying to contact families and ask them for money up to $3,000 to get their children back out of shelters. The process is absolutely free, so you should let anyone know that you're working with that if they are contacted by someone and told that they need to pay money, that is not legitimate and that they should only be talking to the case manager. So some of the barriers to reunification, a major one is that in May 2018, right at the height of zero tolerance, there was a new memorandum of agreement between the Office of Refugee Resettlement and ICE. And what this agreement mandates is that ICE will run the background checks both for criminal history and immigration, and then they will provide that information back to ORR for their determination of the suitability of the sponsor for reunification. The Memorandum of Understanding also stipulates that ORR will provide ICE with the identifying information and all documents that they receive and biographic information, not only about the potential sponsor, but also for all adult members of the potential sponsor's household. And the Memorandum of Agreement fails to place any limitations on the use of this data by ICE and CBP. And so what we think is that this Memorandum of Agreement between ICE and ORR will actually undermine family reunification because ICE is saying essentially that they're going to use these sponsor screenings as a mechanism for immigration enforcement. And in fact, the data is not available yet since the May 2018, but just in 2018 alone, given the general climate that we're seeing, whereas between 2010 and 2015, more than 60% of minors were reunified with a parent, we did see that drop significantly in 2018 down to about 41%. And that's data that is available on ORR's website. What that says to us is that many parents may be seeking alternatives to have someone else sponsor their child, which of course is not the best thing for children, and really making this a law enforcement process rather than a process focused on child welfare. So for parents still in custody, unless the parent is released on bond, there are limited options for reunification. Of course, there is the possibility that parents will be detained with their children, and we expect that to happen with a good number of the parents and children under 5, depending on what happens in court this morning. But what we're also seeing are airport reunifications, meaning that parents who've already received removal orders are being given a sheet, and you can see I have an image of that sheet on the right-hand side of the slide, where essentially they're being asked, do you wish to be reunited with your child and repatriated together, or do you wish to be deported without your child? And Meath will talk a little bit more about this in her section, but what we really see this as a way for the government to essentially say the quickest way for you to reunify with your child is to accept a deportation order. And so we're trying to figure out ways to intervene in that process and let people know all of their options. The other option that is available for parents is that they either are bonded or paroled out of detention and they pursue the ORR reunification process. And I did just include the website of a very new resource that we've been partnering with the Immigrant Families Together project, which is helping to bond parents and pay their bonds and then actually provide transportation and resources to that parent once they are out of custody. So the current litigation impact, the Ms. L versus ICE case on June 26th, the ACLU won a preliminary injunction where the judge ordered that the government reunify all children under 5 within 14 days, which is tomorrow, and all children within 30 days. And there's a continued hearing happening this morning following the government's suggestion on Friday that they may need more time to make these reunifications happen. What we know is that DNA is being used to confirm some of these family relationships as HHS is really struggling to adjust their reunification protocols for these quick reunifications on such a quick timeline. As I stated before, in 2017, it was taking an average of 41 days. So for them to, one, find and link the minors with their parents, but also move forward with the process is a challenge. So the government continues, as they confront that challenge, to suggest that the Ms. L case and Flores really require them to have long-term family detention, which is really not true. The government is not recognizing that alternatives to detention exist. And just a quick advocacy point on this that we hope all of you will use is that the government's own data indicates that ICE operated a family case management program which resulted in a 99% attendance for ICE check-ins as well as 100% attendance at court hearings for families who were released from custody under that program. So they know that it is a false narrative to say that they either have to separate the families or detain them together. There are alternatives to detention, and the government is choosing not to use them at this time. So just as I end my section, I want to mention that for us here in California, unaccompanied children and these border separations are really a local issue. So we're hoping that this webinar today will begin to give some of our fellow CDSS contractors tools so that all of us can help to confront this need. Because while the border separations and many of the families and the children are being detained in Texas, in 2017, more unaccompanied minors were released to Los Angeles County from ORR custody than any other locality in the United States. We had almost 3,000 last year who were reunified here. In 2017, more unaccompanied children were released to the entire state of California than any other state in the country. And in 2018, more unaccompanied minors have been released to California thus far than any other state in the United States. So because these populations are so closely linked, we can expect that many of these separated families, once they're out of custody, are ultimately heading here for California, and they are going to need our help. So with that, I'm going to pass it over to my colleague, Meet Soni, for the next section.
Hi, everyone. So I'm just going to briefly cover the issues involved in representing detained parents who are in immigration court proceedings. And the goal here is really to emphasize to all our CDSS providers that what we can all do to assist and to help parents that we know who have been separated, who are detained, and what type of information and resources we can link them to. So to begin with, we've provided a list of all the detention facilities located in California where parents may be held. There's, as you can see on the slide, there's several facilities located throughout California, and I could confirm for you, just with respect to Los Angeles, we have been encountering parents detained at the Music facility and at the recently at the Victorville facility, which, for those of you who do not know, ICE has recently expanded detention into federal prisons. And most recently, they brought in close to 1,000 detainees in Victorville, and we've met with now many parents who've been separated and who do not know what's taking place in their case. So there's, we have good reason to believe that this is actually not specific or unique to the Victorville facility or to these, individual facilities, but in fact, throughout the state, you will find wherever there's detained populations, there are parents that are being held there. Now, with respect to, there's, as far as we can't tell, there's no practice that ICE has in place in terms of where they decide to detain parents and where they've separated children. We see parents and children who were separated in Texas or were separated in Arizona. The child might be in New York and the parent is now being detained in Music or in Los Angeles. So there's really no rhyme or reason to that. But, so what, I guess like the question from there is what happens, right? When a parent is found in a detention facility, where do they go next? So generally speaking, people who present themselves at the border and say that they're scared to go back, they're, initially they have their first encounter with Customs Border Patrol, who will do an initial sort of screening. And once the individual says that I'm scared to go back, technically that person is then supposed to be scheduled for a credible fear interview with an asylum officer. And later in my presentation, I will speak a little bit more about that. However, under this administration and especially, with Sessions saying with their zero tolerance policy, they've also now decided to pursue criminal prosecutions against individuals who are attempting to enter the United States. And these are individuals who are attempting to enter lawfully to seek asylum, which is their right. However, the administration is using the fact that these individuals do not have lawful status to be present in the United States as a means to prosecute them. So we are seeing cases where individuals have been prosecuted for unlawful entry into the United States, and that results in a misdemeanor conviction of them. And that being said, I mean, there is definitely here, what they're trying to do is use both prosecution and detention as a deterrence for asylum seekers. And as you can see in the slide, what we do, immigration court proceedings are administrative proceedings. They're not criminal proceedings. So to the extent that the administration is deterring people and is making it punitive, for the fact that they're seeking asylum, that is unconstitutional, and that's part of a lot of the litigation that's taking place across the country. So when an individual is able to get past the point of saying that I'm here, I'm scared to go back to my country, and I want a credible, or they should be scheduled for a credible fear interview, ICE will, as Lindsay already explained, they separate the parents from the children. Parents are subsequently detained. In some cases, they might be prosecuted, and after they've served their federal sentence in U.S. Marshal custody, they will then be transferred to immigration custody. So the next question is, what happens to them once they're in immigration custody? Currently, and I think that everyone's been hearing stories of this, and I can verify that it is true, immigration ICE officers are putting a lot of pressure on parents to accept what's an expedited removal order, to say that I'm going to give up seeking asylum so that I can be reunited with my child and I will agree to return to my country. For those, and this is again what we're stressing for all CDSS providers, is our role here is if we can intervene and educate and help sort of provide these parents with the options that they have, to let them know that in fact they should proceed forward with a credible fear interview. They shouldn't give up on their case, because if they do, then they will be placed in regular immigration removal proceedings. So I'm going to speak a little bit more about that. But just, generally speaking, who can be removed from the country? Anyone who's not a citizen, and even if you are a green card holder, if you have criminal convictions, you can be removed. And there's another sort of population that we're finding with the parents who've been separated from their children. These parents may have previously been in the United States and left the country or been deported from the country, and now they're returning. If they do, they're subject to what we call reinstatement-only proceedings because they have a final order of removal against them. And so I'm going to talk a little bit more about that. You know, and once an individual is in detention, the courts are under enormous pressure to process these cases as quickly as possible. So for those individuals who do not have counsel, what we're seeing is that, you know, they're quickly being seen by immigration judges. If they're at a detention facility where the court is not at that facility, such as like it is in Adelanto or Otay Mesa, they will have a video hearing, which is then, you know, they could be video conferenced into a court in Los Angeles, in San Francisco, or even elsewhere, and be given a hearing. But in any case, those hearings take place very quickly. People initially have what they call master calendar hearings, where they're telling the judge, I'm scared to go back to my country. The judge gives them an I-589 application. They submit that application, and then they're subsequently scheduled for what they call a merits hearing, which is essentially a trial. So as I said, expedited removal, this is, you know, the tool that ICE is using to basically pressure parents, especially, and asylum seekers, to give up on their claims and accept removal. And they're doing it under the auspices of separating people and keeping them in really horrific conditions at detention facilities. However, one way for an individual to push back on this is to say that they're scared to go back to their country, in which case the administration or ICE has an obligation to schedule that person for a credible fear interview. And if you receive a positive finding of credible fear, then your case proceeds forward to the immigration court. And this is, you know, just briefly talking about the reinstatement. If an individual has a prior order of removal, but now they're fleeing again their country, and they come to the border with their children, you know, when they present themselves at the border, ICE will see, oh, this person was previously removed. And so technically speaking, that individual is not, does not have a right to another hearing unless they say that they're scared to go back to their country. And so in which case they could either get a credible fear or a reasonable fear. But generally speaking, if they have a prior order of removal and they're caught in the interior, they will be in reinstatement-only proceedings. So I think, you know, sort of the mantra of today is intervention is the goal. And, you know, the government is really relying on the fact that they'll be able to convince parents to give up on their relief, and that, you know, by also forcing them to sort of give up on their relief, they'll also, you know, in response to that, reunite them with their children. But, you know, in the event that a CDSS provider encounters or knows of parents who are being detained, and this could be of the children that you're representing, you might find that the parent is being detained outside of California. If there's any way for a CDSS provider to make contact with that parent, and what we encourage you to do is also inform the parent that they do have a right to apply for asylum and that they should pursue that right, because in pursuing that right, you know, there is, because of certain litigation that's happening around the country, and changes that are taking place because of the public outcry, that this could also help and ensure that they would be reunited with their children. So just to give you, to illustrate an example that I'm speaking of, if there's a husband and a wife who came with their children and they were separated at the border, and let's say the wife was paroled in with the child, but the husband continued to be detained. It is in the best interests of the husband to not accept voluntary departure or not accept an expedited removal order, but to pursue the asylum case, because under recent litigation that started in Washington, the Dennis v. Nielsen case, that the father would now be eligible to also seek parole after he's passed credible fear, and in fact could reunite with the family sooner than what would have been expected. Alternatively, if he pursues his asylum case in court and wins, then both the mother and the child, even though they've been separated, would be part of that asylum application, and they too would be derivatives in that asylum application, and the entire family would actually get asylum status. So it really is in the best interest of families who are actually fleeing persecution to try to hang on and pursue their claim of relief. And so I do also want to let all other providers know that, if you know of any parent who's being detained in the Los Angeles area, IMDEF is representing those parents, and so we are accepting referrals at this time as part of our Keep Families Together project. So this is just a brief overview about what a credible fear interview is. When you find out that a parent is being detained and that they're scared, a question that you should ask them is, have you met with an asylum officer? Has anyone interviewed you? And if they say no, then just letting them know that when they do have that interview with the asylum officer, or if in cases where we've had instances where ICE may not end up doing an interview with an asylum officer and pursue that interview before an immigration judge, please do tell the parent that it's imperative that they provide as much detailed information about their reasons for fleeing their country as possible. Everything that they say, they should be as honest and forthcoming as possible. They should not, that is not the time for them to withhold any information. If there's a reason why they might be feeling nervous, they should explain that to the asylum officer or to the immigration judge. If they feel concerned that any of this information might be shared with their government, you should let them know that the entire process is confidential and private, and at no point will our government share this with the government that they're fleeing under. So, the credible fear standard is whether there's a significant possibility that exists to establish eligibility for either asylum or protection under the Convention Against Torture. And it's the finding of a credible fear is solely based on the interview. In the event that an individual actually has evidence on them, it's very rare for people who are fleeing persecution, and moreover, individuals who are detained oftentimes have their property taken away from them. However, if they tell you that actually I have police reports or letters, please tell them to let the asylum officer or the immigration court know that I do have this evidence. However, the detention authorities have withheld that evidence from me. And so when you come to find out that a parent is detained, one of the things that we found, especially at the Victorville facility, is that there's been a significant delay in scheduling individuals for credible fear interviews. And we again believe that this is also part of the government's way of putting a lot of pressure on them so that people will ultimately give up on pursuing their asylum claim. If you happen to come across someone like that, and your inability to provide advocacy for them and intervene, what we'd recommend that you do is find out who that individual's deportation officer is. Every person who's detained, who's being held by ICE, has a deportation officer designated to them. And the way to find out who a DO is to call that facility and say, I'm calling for this person, this is their A number, I need to know who the deportation officer is. Once you find that individual out, you can then submit a letter on behalf of the detained parent and say that, we're requesting that this individual be scheduled for a credible fear interview as soon as possible. You can also submit a letter to your local asylum office that has jurisdiction over the facility. And, additionally, just to be aware, when there's two things that can happen after a credible fear interview takes place with an asylum officer or an immigration judge, is that, they could either find that you have a positive credibility finding, in which case your case moves forward and then you're allowed to apply for asylum and present your entire claim. Or if an asylum officer finds that you do not have a credible fear, either because there's inconsistencies, there's not enough detailed information, you haven't actually shown that you're going to suffer persecution on a protected ground, and there's no threat of torture, then they'll not find in your favor. You are then subject to expedited removal. However, the detained parent has an opportunity to challenge that determination before an immigration judge. So if that's something that you become aware of, that someone that you're working with has ended up with a negative credible fear, please encourage them to pursue review by the immigration court, because we have seen many instances where the immigration judge will overturn that finding, and then the individual will be allowed to actually pursue their asylum claim. So, recently, because as I mentioned, the litigation with the injunction order that came out of Washington last week, Damas v. Nielsen, that case, the case came out of Washington, D.C. That case involved people who are being detained at 5 facilities in the country, one of which is Los Angeles, and where, in the past year, ICE has sort of persisted with rejecting parole requests by asylum seekers. And under this injunction order, the court is now required that all class members, so all those who are being detained in the Los Angeles area, at least, be given an opportunity to have their request for parole be reviewed. And so there's, a requirement, again, being placed on ICE that you need to follow your policies of doing an individual case-by-case determination of whether this person can be released on parole. And the determination for parole release is very similar to what it is for people who are in immigration court requesting bond. The applicant must demonstrate that they are not a danger and that they are not a flight risk. In the parole context, this means that as part of your request for parole, the detained parent must submit evidence of sponsorship and support from a U.S. citizen or a legal permanent resident. And it can be a family member, it can be someone, but it can also be someone from the community. We've had many instances where visitation groups, for instance, that are organized by local church members would be willing to provide that sponsorship, and they'll present that letter, and in fact, even for a temporary period of time, provide shelter to the parent and the child if they are actually released. So this is yet another sort of way of providing hope to detained parents that you might encounter at the detention facilities. Otherwise, if in your jurisdiction, if you're for those who are representing people in San Diego or in Central California where this injunction does not apply, we encourage you to still encourage detained parents to make that request for parole, and where possible to make sure that they're providing the proper evidence. However, if parole is denied to them, then they would technically not be allowed to seek bond. Bond under the laws are only allowed for right now because Rodriguez v. Sessions was overturned by the Supreme Court. And so for facilities or detained parents who are located outside of the Central District Court jurisdiction, they do not have an opportunity for bond because they're an arriving alien. And under 236C, which is mandatory detention, those who are arriving aliens are considered mandatory detainees who are not given regular bond. However, if an individual, a detained parent, was actually caught in the interior and in their notice to appear, they're not designated as an arriving alien, and this is someone, if you look at their notice to appear charging document, it says that you were caught, in the interior, you've been found inadmissible because you don't have proper status, then that person actually would be eligible for a regular bond hearing under 236A. And, to seek bond, again, they would need to demonstrate that they're not a danger to the community and that they're not a flight risk. So finally, I'm just going to end my presentation with just speaking really quickly about what we are seeing at the Victorville Federal Prison, and we believe that what's happening there is actually indicative and emblematic of what's probably taking place at the other detention facilities. At the facility, there's 1,000 or so detained immigrants, mostly they're asylum seekers. What we've found is that they've been, brought to this facility after having been transferred and moved around from many different facilities. And I think that you'll find this to be the case for many people who are being detained in California, that they again came from Texas, came from Arizona, and then they've just been shipped around and they do not know what's taking place in their case. We've been, what we know is that the detention conditions are pretty horrific. They've been on lockdown or in solitary confinement. There's been an outbreak of chicken pox and scabies, and in general, they've not had access to medical or mental health care, and that they've definitely been repeatedly denied access to legal representation, either by not having access to phone, or when speaking to ICE about their case, immigration will just tell them that, look, you're just going to end up staying here for a long time, so you should just really accept deportation. There's no one that can really help you. And that across the board, we've seen that there's no language access being provided. So I think that this is just, again, to highlight and flag for our fellow CDSS providers, because you might find that a child that you're working with has a detained parent who's in these circumstances. And if you know of anyone who's being held at the Victorville facility or any of the facilities in Los Angeles, please do notify IMDEF staff, because we are ready and able to provide representation and connect that parent to resources. We are also able to represent any of those united families that you might know of who've relocated to the Southern California area. And so this is just the last slide I just wanted to go over, is just some helpful information for everyone. A lot of people don't know that there is a EOIR court information hotline where you can, if an individual is in actual immigration proceedings, they have an A number. If you input that A number, you'll find out when that individual's next court date is, where that individual's court date is, which can be really helpful to ascertaining where the detained parent is being held. There's also the ICE detainee locator, where allows you to locate a person in ICE custody by searching through their A number or by their first and last name and country of birth. Finally, because again, the fact that they're prosecuting many individuals who are seeking asylum or trying to enter the United States, you might actually be able to find a detained parent who's being held in a bureau of prison location. And for that, you would also need their name, race, age, and sex in order to be able to locate them. And with that, I'm going to hand over the presentation now to Shana Kessler at the Vera Institute. Thank you.
Thank you very much, Meath. I am Shana Kessler, a senior program associate. Sorry, I'm looking for the presentation screen. I have lost the presentation. If somebody might be able to take over for me, the tab's not appearing. But I'll just continue on. I'm a senior program associate with Vera's Unaccompanied Children program and a member of the team at Vera that has established ICON, or the Immigrant Connection Project, in collaboration with New America. As Lindsay described, Vera's Unaccompanied Children program funds a nationwide network of legal organizations who provide legal services to every unaccompanied child in ORR custody. The government's policy of separating families has brought new and unprecedented challenges to our network across the board. So while the legal organizations that we work with had always been accustomed to working with some children who were very young or who had been separated from their families, their routine work involved children who had made a decision to come to the United States on their own or with siblings and were prepared to describe the conditions that had led them to make the journey. And that information is what's really essential to a legal professional's ability to assess the person's rights and legal options and provide clear and sound advice. So that was the typical circumstance that our legal service providers had previously been operating in, counseling and advising children with whom they could communicate effectively. So we learned from our providers in California and across the country that working with this enormous increase in children who had been separated from parents was causing unprecedented challenges for legal service providers and for the children that they serve. They were now in a position of, they were now in a position of attempting to conduct legal assessments and provide advice to children who were toddlers, too young to communicate at all. Other children, even if they did have the ability to communicate, were far too traumatized at having been torn away from their parent and couldn't express anything more than a desire to be, to see their parent, to be reunited. And even those who were able to communicate never expected to be unaccompanied. They never expected to be without their parent to begin with. So they didn't have the information or documents that they needed for a legal service provider to conduct a proper legal assessment. Thanks. It looks like we are back on track. So I think I should be able to take over. Oh, there we go. So apologies for the technical challenges. We can leave it there for now. So our providers struggle to learn if a child might have a valid claim for asylum or for another form of relief. And in some cases, a child might have an asylum claim based on facts that they never even knew, even if they are able to communicate, for example, as a derivative beneficiary on their parents' asylum application. There'd be no way for a legal service provider to access this information without speaking to the parents. So many children who'd been separated from their parents were simply incapable of sharing information that is essential to understanding their rights. And at the same time, our legal service providers were reporting that when they attempted to locate the parents of separated children to be able to gain access and have conversations to learn the necessary facts to conduct a proper legal assessment and to permit families to make decisions about their legal options jointly, they hit roadblocks. They were unable to track down many of the parents, unable to speak with them in many instances. So Vera decided to team up with New America to help ease these unprecedented challenges that resulted from the policy of separating families. We were able to do this because our network provides us with detailed reporting on the work that it does with children in the custody of the Office of Refugee Resettlement. So with the data from our network, we were able to locate nearly all of the children in government custody, including the foster care programs that Lindsay was talking about. And what we've done is we've set up a system to respond to requests from parents and their advocates who were separated from their children and unable to locate them. We know that DHS and ORR are working to reunify children and to come into compliance with the judge's order in the Ms. L litigation that requires that they do so. But that's not a process that's happening immediately. Tomorrow, of course, as many know, is the court's deadline to reunite all children under 5, and children older than 5 are supposed to be reunited by the 26th of this month. Unfortunately, the government has already indicated that it will only be in partial compliance with this order as of tomorrow with respect to the under 5-year-old children. And so it's clear that many children, even some of the youngest, will remain separated from their parents for an indefinite period to come. So that's why we're solidifying our efforts, doing everything we can to be sure that parents looking for their children are aware of our Immigrant Connection project and able to reach us to help get in touch with a legal service provider working with their child. So parents and advocates can contact us in a variety of different ways. There's obviously a toll-free number. Parents in ICE detention and immigration detention can use the free calling system in their facilities and reach us directly. And of course, we have email addresses as well. We're continuously working to make it easier for people to reach us. That 800 number will very soon be an international toll-free number so that parents who've been returned to their home countries without their children, which is something that has happened, they may be able to reach us and connect with the legal advocates working with their children as well. So thus far, ICON has had a 90% match rate. We've been able to connect the parent with the legal service provider working with their child for 90% of the requests we've received. We respond to every request we receive within 24 hours of receiving it, and sometimes are able to get back to people much more quickly than that. And the result is that we've been able to put parents in touch with the legal service providers providing services to their children, so they can reestablish contact, better understand their legal options, and make decisions as a family about how to proceed. ICON is just one of many, many efforts underway around the country to address the damage caused by the administration's family separation policy. Organizations like Raices, Freedom for Immigrants, are just two of the many additional organizations engaged in helping children and their advocates locate parents in detention. They have web forms that I've linked here to request a search for a parent. And their efforts really represent sort of the other side of the coin from what ICON is doing. At ICON, we are using VERA's unique access to information about children's legal service providers to locate that legal service provider when parents are searching for their children. And these other efforts are helping to locate parents whom children and their advocates are unable to find. So in combination, our joint efforts will hopefully enable all families that were torn apart by the administration's policy to reconnect. I've also flagged a couple of other resources here. There are many, many more that are not listed. Raices, in addition to doing the searches for parents, has instituted a hotline and a web form to assist people seeking legal services and who need help paying bond. Another one, of course, was mentioned by Lindsay and Meath, the Immigrant Families Together project that they're working on. There are lots of other organizations doing this work, and I hope to see some national coordination to make accessing these services more easy across the country shortly. But in the meantime, I really do encourage a lot of creativity and aggressive searching for advocacy organizations and folks on the ground in the different areas that you might be looking, as there's a lot of effort in this area and a lot of excitement and a lot of people working really hard. So there are a lot of new and developing resources around the country, and hopefully we'll see some coordination on that front so that it'll be easier to track things down shortly. So as these efforts continue, at ICON, we hope to do everything we can to enable parents and children who remain separated, still numbering in the thousands, to reestablish contact as soon as possible, enabling them to work with their legal service providers to understand and make decisions about their legal options and their futures as a family. So I'll end it there. I'm happy to take questions in the time we have left. Thank you very much.
Hi, everyone. Thank you so much for calling in and participating in the webinar. My name is Odette Fordham with CDSS. There was a couple of questions. Since Shana, you last left, why don't we start with the questions we have for Vera? So one of the questions was, how can we connect with the Vera's network?
You can certainly reach out to me or anyone, or at any of our, I think that's probably the easiest way to reach us is through our email address, which is the information that was provided on that slide. There's, in English, it's familyconnect@vera.org. And there's the Spanish version, which goes to the same email box as well, familiasunidas@vera.org. And folks can certainly, that's one good way to get in touch for sure.
I believe there's a couple questions for immigrant defenders. One of the questions was, do you have an approximate count of how many parents are in Victorville?
So it's actually been difficult to get information, in part because the government is really being somewhat obstructionist about who's being detained there. However, we're already representing at least one parent who's being detained there, and we've learned from local consulates who've been interviewing individuals there that they've at least identified close to 15 parents. I can tell you that the last week when we tried to go in to meet with some of these individuals that we believe that we have information from who are parents, we were denied access because they were supposedly under quarantine, or the individuals was no longer at the facility. So so there are parents being detained there, but it's very difficult right now to know what the exact number is. And I don't know if we ever will figure out what the exact number is.
And a second question for immigrant defenders. I think this is more of reuniting parents or sponsors. So does the case manager need to personally meet with the family?
So the case managers don't necessarily need to personally meet with them. They'll be in direct contact with the family. However, oftentimes, as we've discussed throughout this presentation, the families are separated on different coasts. They're in different states. We're currently working with multiple families who've been released to the LA area, but their children are in New York or Texas or Arizona. And so the case manager will be working at the shelter where the minor is currently detained. So oftentimes the information that they're receiving is by phone, and also getting documents directly from the family sent by email or mail. However, in cases where there is some sort of an issue that has raised red flags for child welfare issues, oftentimes the case managers will say that the child cannot be released until a home study has been done, which then would be conducted by through subcontract with a local social services agency near to where the parent is living or the potential sponsor is living. So in those situations, we do see significant delays. And it's yet to be seen how many of these cases, particularly because they're dealing with such young children, and many of the separation cases will require that extra level of scrutiny. But generally, families should expect that if they are working on reunification paperwork, that it will be done mostly by phone and by email.
Great, thank you. I think there's a follow-up question to that. Do you have a sense what happens with parents who are being deported and who have asked for reunification with their children? How does the child get out of OR? Have the kids been issued NTAs? And if so, are those NTAs being withdrawn, or is there another process for these children?
So we've seen a couple of things happening on cases where we represent the minor. We have seen, and as some of you may have seen in the media over the last 24 hours, in some cases where the parent has already been deported, lawyers are requesting voluntary departure for the minors so that they can be reunited with the parent in home country. And that can be done in a way where their legal status for future ability to return to the United States is not impacted, because it will be a voluntary departure as opposed to a deportation order. However, we are also representing cases where, and this was the situation that both Meath and I discussed earlier, where parents are able to reunify with their children, for example, at airports, because the child's NTA is canceled prior to that child making an appearance in court. And in those cases, the reunification happens quickly, and then the parent, as their deportation order is carried out, are reunified, and the family is repatriated together as a family unit. And as we mentioned, this is one of the reasons that it's so important for all of us here in California to be intervening in that process, so that parents don't make that decision because they think that's the only way that they can be reunified with their child, but that if they are considering that they make an informed decision that lets them know about all of their legal rights that they have as they make their decisions in this process.
Great, thank you. We have another question, and again, if Vera also wants to answer some of these questions, again, feel free to, whoever wants to answer this, but can you provide more information regarding the bond eligibility requirement for asylum seekers? And is this an area that organizations or philanthropy would consider funding?
Yeah, so, as I said, for those who are detained outside of the Los Angeles area, outside of the Central District, unfortunately, for individuals who are arriving aliens, and that's someone who is an asylum seeker, they are not eligible for bond. And the only reason right now and why I make that sort of distinction between the Central District and other areas is because the Rodriguez v. Sessions injunction is still in place in the Central District because it has yet to come down and be reversed by the Ninth Circuit. And so for those who are detained in the Central District, we are actually able to pursue what's called a prolonged custody redetermination hearing, and that doesn't take place until an individual has been detained for 150 days or longer. At that point, the burden then shifts to the government to demonstrate that the person is a danger or a flight risk. And now, so with respect to whether there's a role here for philanthropy or other foundations to set in, I think that for those who are in the Central District area and actually are able to get bond, even though the court is required under a different lawsuit called Hernandez v. Sessions to set a bond that's affordable, for many asylum seekers, even a $2,000 bond is impossible to meet. However, that might be the least amount that the judge is willing to grant. So I think that is a place where a lot of philanthropy might be able to help and create a bond fund or fundraise.
Great. Another question is asking, where should we direct attorneys who want to volunteer in their region?
So in terms of volunteering at the Victorville detention facility to help us with screening, and as Mead mentioned, just in the first few screenings we already found someone who had been separated from their children. So this is an area that is really important for volunteers. We are holding a training tomorrow evening at the ACLU of Southern California in conjunction with them for people that are interested in volunteering at Victorville to provide legal screenings. We will also, for experienced immigration practitioners, be referring cases for people who are interested in representing people either for their CFI preparation, their bond hearings, or potentially in their full removal case. From the folks that we screen at the Victorville detention facility. One of the things that we are also trying to make clear to everyone is that because of the Vera Institute of Justice network, the children who are currently detained in California have their legal services covered by our the community of network of providers here. But there will be a need for pro bono attorneys once some children are released and out in the community. Kids in Need of Defense and other organizations, Casa Cornelia, place cases for pro bono representation. So I'd encourage you to reach out to them. But sort of in this immediate term, the most immediate need right now is for assistance with that or legal screenings at Victorville. And that information is on IMDEF's Twitter and our Facebook page. So if you'd like more details, we can also ask CDSS to send that information out for folks in the greater LA area.
Great, thank you. And just to wrap up, someone else asked if they could have a copy of the flyer. Have you been separated from your children? I believe I posted that, and it's included in the webinar. And just for all the participants, we will be sending a copy of the webinar in PDF format, so that that flyer PowerPoint piece will be included as well.
All right, with that, we will wrap up the Q&A session. Thank you everyone who joined us for today's webinar. If you have any additional questions, feel free to reach out to the presenters directly. The presenters' contact information is in the presentation slides, and we will share the recorded webinars link along with the presentation slides with you all today. Again, thank you all for your time, and have a wonderful rest of your day. Thank you.